on notice of it. Of course, what I would have done is I would have discussed with Mr. Estrada, you can't mess with the witnesses, but I can only prepare him for what is in the records. In other words, there is no record of these people either being a subpoena being requested or issued.
So is your argument that if there are witnesses in a case, unless they're subpoenaed, a defendant can tell a witness, don't show up?
Well, if a person has not been subpoenaed, the law allows you to tell them you don't have to show up.
No, not you don't have to show up, but tell them not to show up. That's what the allegation is, that he told a witness not to show up, not that you don't have to show up. I've been a defense attorney, and I know that people have told people, hey, you haven't been subpoenaed, you can show up or not show up. If you've been subpoenaed and you don't show up, one or two things are going to happen. Either the state is going to be like, well, whatever, they didn't show up, or either they're going to want to do an attachment. So
I am returning to what I know to be the law. And the law is that we are entitled to two things. Number one, all the discovery on the case that
I'm talking about the asset, the forfeiture.
So the forfeiture by wrongdoing, I do not know whether, because I have a case here that the standard is that it has to be wrongful, right? And so the question is it wrongful? Well,
the question is it wrongful to tell somebody that they don't have to, that they don't show up to court? Is that wrongful to tell somebody, do not show up to court? If you show up to court, then I'm looking at 25 years. Is that wrong to do?
I believe that is the question. If that is in fact what it said, which of course is the real problem we have here. So what I don't like to do is I don't like to be at the last minute. They're saying it's in some other discovery. I don't know that.
No. I want to talk about this forfeiture by wrongdoing. That's what I want to talk about.
Yes, ma'am.
So let's figure that out, and then we'll come back to this discovery issue.
Okay.
So that's my question. So basically, and I don't know if this is your argument or not. So are you saying that if there's somebody in custody or not in custody on bond, well, no, let's say they're in custody, that you get out of a trial, all they have to do is, if your trial is on, let's say, hypothetically, February 6th, you can call somebody on February 5th and tell them not to show. And then the defense attorney can say, excuse me, I need more time. I'm just learning about this. And then let's say hypothetically that person gets a continuance, and their continuance is, let's say it's for March 12th or whatever. I'm just doing a date. And so that defendant knows their court date, their trial is set for March 12th. So they say, you know what? Let me make a phone call. And they make a phone call on March 11th telling somebody not to show up for court, because if you show up for court, things are not going to go well for me. And then the defense attorney can come in and say, hey,